Greetings and salutations, my fellow sovereigns. This is Vocational Science Freedom, Saturday Night Civics and Sovereignty class. And tonight we will be continuing our reading from the Treatise on American Administration. Okay, without further ado, let's just get into the links. So if you guys want to bring that both up so you can follow along. Okay, so we're on left off on page 223. So subsection 31. Incapacity arising from undue influence. Undue influence to vitiate a will must be such as caused the testator to dispose of his property contrary to his judgment or desire, in consequence of fraudulent representations or importunities and external pressure which he was too weak to resist, and hence always contains an element of coercion or fraud destroying free agency, if his judgment was not misled by false representations, nor his will overpowered by irresistible importunities. So the little footnote here, to invalidate a will on the ground of false representations to the testator, it must be proved that such representations were made, that they were false, and that the disposition of the will was made in consequence thereof. Now, as in when someone suffers from long-term dementia, if you have not made sure that your elderly kin have a will, you should do so immediately, because as we're being poisoned more and more by our enemies, the potential for dementia has increased almost exponentially over the last, I would say, 10 years, maybe even going back to 20 years. And if you do not make sure that your elderly kin have performed and created a will prior to them experiencing any sort of dementia, then they will not literally be able to create a will. Because once dementia has started to take hold, and if they're, going to regular doctor's visits, the doctor will write down in the medical records that said individual has started to show signs of dementia. The second that they write that down in the medical records, anybody can then come in and grab those medical records and invalidate any will after that date. And of course, that can also work in your favor as well in some way, shapes, or forms. If you have a evil or nefarious family member that attempts to alter an elderly person's will after they've started to suffer from dementia to benefit themselves, well, then what you need to do is you need to go and get the medical reports that clearly state that, yes, they had been suffering from dementia, and so therefore that will is invalid. And this gets into opening a probate case and what to do when a probate case is open. And if there is no probate case that has been opened, you always want to open a probate case in what's called solemn form. Probate in solemn form is where every single document is verified and everything's put on the record. And that's the way you should always take care of any aspects of will and probate. So just to make note of that also, that when you're in court, if they don't see you as competent or have some sort of incapacity, and we spoke of incompetency before, I think in the last class, so this is kind of a continuation of that, but incapacity from undue influences. Undue influences also have to deal with things like cops giving you orders, right, on the side of the road. Say, well, that's not my will. I didn't wish to do that, right, or I was forced to do so, such and so forth, right? It's the same way that you would invalidate any sort of contract that's ever done under undue influence or coercion is also invalid for that exact same reason. Okay, so I think I'll skip down from there to, let's see. Oh, okay, just another subsection here. In a word, a testator may be led but not driven, and his will must be the offspring of his own volition, but not the record of someone else's. And that's the whole point. No one else can make the will but the testator themselves. And then no influence brought to bear upon him can invalidate his will, because it is in such case free from the element of coercion or fraud. No precise line can be drawn distinguishing legitimate from unlawful influence, except the general one thus indicated. But it is held that considerations addressed to the testator's good feelings, simply influencing his better judgment, the earnest solicitations of a wife, or the exercise of influence springing from family relations, or from motives of duty, affection, or gratitude, persuasion, argument, or flattery, kindness, and attentions to the testator, and influence worthy exerted for the benefit of others, cannot be considered as undue as to affect the validity of a will inspired thereby. So if you're just being nice to the person who's sitting next to you writing the will or signing the will, or you're talking about creating a will, and say you're talking to your mother or your father or your grandfather, whoever, and they're just asking you questions, and you're just saying, well, Grandpa, you've always been so nice, and it's just great that you want to do this for so-and-so, whatever. That's not considered undue influence. Okay, that's what that's getting at. Okay, now we're going to skip down to section 32, and the rest of this class, the rest of this treatise, I should say, we're going to be skipping a lot because there's far too much detail in a treatise of this kind to really have to read every bit of it. And a lot of it, I'm not trying to teach everybody every single aspect of wills and testaments. I just want to cover over the main parts and give you the sections that I think are important in regards to what they're doing in the system that they're running of basically probating everybody's will, and that they are administering everybody's estate from birth to death because we do not have a valid will. Okay, so 32. Presumption against legacies to fiduciary advisors. The rule that undue influence may never be presumed must be proved by the person who alleges it, is subject to an exception in those cases in which a legacy is given by a testator to his attorney, confidential advisor, guardian, or other person substaining towards him any fiduciary relation. Proof of the existence of such relation raises the presumption of undue influence, meaning, yeah, if the will pops up and all of a sudden the attorney, the man's attorney, has half of the estate, slightly suspect, right? So proof of the existence of such relation raises the presumption of undue influence, which is fatal to the bequest unless rebutted by proof of full deliberation and spontaneity on the part of the testator and good faith on the part of the legatee, the one that's getting the stuff. The presumption extends beyond the period of minority in case of guardian and ward, so as to invalidate a will made by a person in favor of his former guardian a few days after attaining majority, right? So that would be also very suspect. Okay, somebody just comes of full age, all of a sudden they make a will, and they're giving half of their estate directly to their guardian. Well, yeah, who probably had influence on that? The guardian, right? So, and a bequest to the wife of a guardian likewise gives rise to the assumption where it appears that the guardian may expect and derive substantial advantages and benefits from such will of his ward. Right. And that's kind of what the attorneys and that's kind of what the whole system is doing anyway. The whole system is taking a percentage or part of your productive value of your estate, and then they're administering it, and they're hypothecating it, and they're turning it into worthless Federal Reserve notes, right? Which is how Federal Reserve notes even get created. They're all created on the backs of our productive value in our estates. So in a weird way, the attorney's kind of doing this anyway in the system, but not from a standpoint of necessarily a last will and testament. It's just that there has never been a proper will of ours ever placed onto the record. And so it's all being done by presumption of death and presumption of administration that there is no valid will, which is why we make sure that we create valid wills and that all of the VSOF status docs are considered a continuation of your will. Okay, so I'm going to skip down to chapter 5 here. This is page 232, if you guys want to jump down here with me. I know I flipped through that pretty quick. Okay, so chapter 5, form, execution, and attestation of wills. Subsection 36, absolute and conditional wills. The office of a will, more accurately called last will or testament, is to control the disposition in the manner desired by the testator of his property after his death, and in many of the states, as in under the statute of 12, I think that would be Charles II, C-24, to appoint a guardian for his minor children. In its essential nature, a will is ambulatory, for it is not operative before the testator's death, until which time it can vest no rights in others, and may therefore be revoked or changed at the testator's pleasure. Okay, now that's all well and good, but when the presumption is that you're dead, your will's already been probated already. So the presumption of the ambulatory part is already kicked in, right? Which is how they operate the whole system. Okay, so it is usually absolute in its provisions, but may be made conditional upon happening of some event, and then it's void unless such event happens. And an example of that would be something like my second son gets half of my estate, but only if he graduates college within 5 years, right? Something like that. That would be a if then this kind of situation. Okay. Okay, so I'm going to skip down to the next place where I've got a note, which is quite a few pages down to page 238. Subsection 38. General rule as to the forms of wills. It is unimportant to notice in this connection the various solemnities and formalities required in different countries and in various times to make a valid will or testament, because this matter is regulated by statute in each state as well as in England and will be considered at the proper time. But it is necessary to bear in mind the distinction between personal and real property in connection with its testamentary disposition, and that, while at common law, real estate could not be devised, the power of making a will of personal property existed in England from the earliest period of its law. And the reason for that is because back then, all of the land belonged to the king, basically. That was the reason. But to continue, the power to devise lands after the conquest, that would be William the Conqueror, 1066, Norman filth coming over and fucking everything up, was first granted in England by statute of 32 Henry VIII, from which, and that of 29 Charles II, the American statutes regulating devices are substantially taken. Although both in England and America, the formalities required to vindicate the validity of wills of both real and personal property are now prescribed by statute, yet the distinction existing between legacies, meaning gifts of personal property, and devices of real estate. So know that there's the difference between that. So a legacy is something of personal property, stuff you can move around that's not attached to the land, and devices are ones of the actual real estate themselves, land themselves. Okay. At the time of the enactment of the several statutes is not wholly obliterated, and the common law rules on the subject of wills remain in force as the law of most states, insofar as they are not abrogated by American legislation, which is something that I brought up, I think, either one or two classes ago when we were reading this, and I read the Illinois statute that the common law is in still full force and effect until it is altered or changed by the legislature. And in a lot of cases, it has not been. So you can use the common law to take care of your business, right? But to continue, it is necessary, therefore, briefly to review the common law in this respect before considering the provisions of American statutes. At common law, no particular form is necessary to constitute a valid will of personality, and the same is true of all wills in America, save as modified by statute. Okay, so there's nothing specific. So no particular form required at common law or under American statutes. Okay, so get that. That's very important. No particular form. So that means, can you verbally state your will? Yes, you can. So you can verbally state it in court because there's no requirement. There's no particular form required, and it'll get into verbal wills here in a little bit. Okay, and then it may operate as a valid will, although drawn in the form of a deed poll or an indenture or a deed of gift or a warranty deed, a bond, marriage settlements, letters, drafts on bankers, the assignment of a bond, note, bill, or stocks by endorsement, promissory notes, and notes payable by executors and administrators to evade the legacy duty. A power of attorney may be in part a deed or otherwise contract, and in part a will, or it may be intended to operate as a deed, bond, or other instrument of gift, and yet, though inoperative as such, be valid as a will, if it provide for the disposition of property after death. Okay, now let me unpack that, because there's a lot of words in there that a lot of people probably don't understand. So open up the vocabulary, and we're going to kind of click through this here a little bit at a time. I grabbed as many as I could. I couldn't really grab all of them because some of them I think I have to dig into bankers' dictionaries to really pull out proper definitions. Because when you get into things like promissory notes, and bank drafts and things like that, you really do want to look those words up in a proper banking dictionary. They sometimes will have an okay definition, maybe sometimes in Black's, but a lot of times you won't find them in Bouvier's. But the best place to go find them is literally just in a banking dictionary. So just know that. But at least I grabbed some of them. So what are they talking about here? Okay. They're talking about the fact that no particular form required at common law or under the American statutes, right? So this is the thing. It may operate as a valid will, although drawn in the form of and then it has all of these lists of things, right? So let's start looking at these things. Okay, so what's a deed poll? Deed poll, this is from Black's Law 9th. A deed, and I'm going to blow this up a little bit. It's probably too small to see. Hold on. A deed made by and binding on only one party or on two or more parties having similar interests. It is so called because traditionally the parchment was polled, that is, shaved, so that it would be even at the top, unlike an indenture, also spelled deed poll. Now, I didn't know that interesting part about the shave thing until I looked it up today. But get that, a deed made by and binding only on one party. Okay, so a deed poll can be something that is only binding on one party, right? So that's an interesting thing of that. Or an indenture, and I think I put indenture in here. Let me scroll down. Okay, indenture. Conveyancing, an instrument of writing containing a conveyance or contract between two or more persons, usually indented or cut unevenly or in and out on the top or side. Formerly, it was, and this is weird that they used to do this as far as how they would cut the page. Formerly, it was common to make two instruments exactly alike, and it was then usual to write both on the same parchment with some words or letters written between them through which the parchment was cut, either in a straight or indented line, in such a manner as to leave one half of the word on one part and half on the other. Oh, I see why they did this. Okay, because you're signing one thing, but both people get a piece of the original contract. I see what they're doing. Okay, so that's why it had to be cut like that. All right. Okay, the instrument usually commences with these words, this indenture, which were not formally sufficient unless the parchment or paper was actually indented to make an indenture. But now in the form of indenting the parchment be wanting, it may be supplied by being done in court, this being mere form. Besides, it would be exceedingly difficult, even with the most perfect instruments, to out parchment or paper without indenting it. Okay, so that's an indenture. A deed of gift I didn't put down. So a deed is just an action or a thing done. So something that you would give as a gift. A warranty deed, that one I did grab. So a warranty deed is a deed in the real estate document that protects the buyer and ensures that the seller holds a clear title to the property, has no outstanding liens or mortgages, and there will be no future claim to the title of the property. The two parties involved in a warranty deed are the seller, known as the grantor, and the buyer, known as the grantee, and either party can be an individual or a business. Most lenders require a warranty deed for properties they finance, and this definition I got from Investopedia because I couldn't really find a good definition any other place currently. So again, they're saying right in here that it may operate as a valid will though drawn on these various different things. Okay, so can your will, and this is the point, the only reason I'm stopping and going through all this, can your will then be written onto a negotiable instrument or a bond, right? Because it says bond right here. Right. Yes, it can. Okay. What is the birth certificate? It's a negotiable instrument. It's on bond paper. So what do? We at the VSOF flip the thing over after we've got it authenticated at both the state and federal level, because then you actually hold a title to yourself. We then properly endorse the back of it and give instructions by will as to what needs to be done with that instrument, because it says right here that you can do that. And that's exactly why we do that. Okay. So I'm going to go through some of these other ones. I don't know if I grabbed all of them. I don't think I put bond in here. Bond's basic. Everybody knows what bond is. I couldn't find marriage settlement anyway. I think what they mean by marriage settlement is probably a settlement after maybe a divorce, I'm thinking, but don't hold me to that because again, I'm not sure. Letters, that was actually letters I did put in here because letters is something that I thought was that most people probably do not know what letters are. A lot of times you'll see the word, like say, letters patent in various different older law about things that the king would do. So, okay, so here's what a letter is. Okay, letter, common law, criminal law. A pistil, a dispatch, a written message, usually on paper, which is folded up and sealed, sent by one person to another. A letter is always presumed to be sealed unless the presumption be rebutted. Now, under this particular definition of letter, under the common law and criminal law, there were many more definitions in there. But every single thing that is in bold like this is taken out of Bouvier's, okay? And, well, every definition that's in this vocabulary word list comes from Bouvier's unless it is specifically stated that it is not, which I stated for blacks and obviously the website that I grabbed the other one from. Okay, so, but just know that this letter, this particular definition of letter goes on for quite a while, but that was not necessarily the one I wanted to focus on. Okay, letter contracts. In the civil law, locator, and the French law, is he who, being the owner of a thing, lets it out to another for hire or compensation. Number 2, according to the French and civil law, again, civil law being Roman civil law, in virtue of the contract, the letter of a thing to hire impliedly engages that the hirer shall have the full use and enjoyment of the thing hired, and that he will fulfill his own engagements and trust in respect to it, according to the original intention of the parties. This implies an obligation to deliver the thing to the hirer, to refrain from every obstruction to the use of it by the hirer during the period of the bailment, and a bailment is when you give something to someone else to hold, to do no act which shall deprive the hirer of the thing, to warrant the title and possession to the hirer, to enable him to use the thing or perform the services, to keep the thing in subtle order and repair for the purpose of the bailment, and finally to warrant the thing from any fault inconsistent with the use of it. So when you do a letter, you're saying, hey, you have this thing and I have no more control over this thing. I'm letting you use this thing and I'm not going to fault you for how you use it. None of that. Okay. Right. Okay. So these are the main obligations deduced from the nature of the contract, and they seem generally founded on unexceptionable reasoning. It is difficult to say how far, reasonable as they are in general sense, these obligations are recognized in the common law. In some respects, the common law certainly differs. Okay. So you can get, because again, what are they talking about? Contracts and civil law. So letters under common law and letters under civil law are different. That's why I kind of wanted to bring this up, because I don't know if I've ever spoken about letters before in any of the classes. So I just kind of wanted to make a note of it here because it came up, and I thought this was a good place to just kind of give an introductory to what the aspect of what letters are. But certainly you do want to go to Bouvier's, just go grab it off of the VSOF mega download for the law library, and just download all of Bouvier's and make sure that you go and read the totality of that specific definition. And then this one, letter, this is just civil law. So letter, the answer to which the prince gave to questions of law which had been submitted to him by magistrates was called letters or epistles. Okay. So when we're getting anything as far as letters from an attorney or from a court or from a judge, I don't know, maybe we should consider them epistles and answer them in accordance with our sovereignty and say, well, if you're asking me about questions of law, Your Honor, then this is my law. But I'm kind of joking, but at the same time, I'm kind of not, because that's what we're doing when we're executing our vocational science freedom status docs. We are ordaining and establishing law. We're creating our own law of the domicile, and we're saying to everyone else, hey, this is the law in regards to any administration of our estates. Okay, so I think that was the only other one that I had on there. Warranty deed and testate. Yeah, I don't think I did. Yep, did indenture. Okay, I think I covered all the rest of the ones that I could find, at least, that were in that little paragraph. So I'll just finish up the paragraph then. Okay, so I'll just jump down the next page because we read that. Okay, notes payable by executors, administrators, duty, power of attorney. It may be in part. Okay, so I read all the way down. I think all the way down to here. So bond or other instrument of gift, and yet, though inoperative as such, be as valid as a will if it provide for the disposition of property after death. Again, so this is the reason why we put the endorsement on the backside of the authenticated the duly authenticated birth certificate. And then it gets attached to the Vocational Science of Freedom status doc, which is called the BC claim. That's the short name for it. Okay, so we're going to skip down to section 39 now. The signature. Under the English statute of frauds, all devices of lands and tenements were required to be in writing and signed by the party devising the same or by some person in his presence and by his express direction. This provision is incorporated into the statutes regulating wills in nearly all the states, and a declaration is added in many of them that unless so signed, no will shall be valid. The making of a mark by the testator was held sufficient as a signature under the statute of frauds without reference to the question whether he could write at the time. It is held equally sufficient under the Wills Act, and in the general states, the mark of a testator has been held a proper signature, although the name was improperly written by the scrivener. A stamp, which has been used by the testator in place of his signature to letters and other documents, was held a sufficient execution by mark. And of course, what they mean by a stamp is a signature stamp. They don't mean a postage stamp here. But this is an interesting part. But a seal cannot be used in place of a signature, although it was at one time so held that under the statute of frauds. So at one time under the statute of frauds, you could do it, but so you need to have everything signed and sealed, right? And it says, nor is a seal necessary, although mentioned in the testamentary clause. Now, we seal everything anyway because not only are all of the vocational science freedom status docs a perpetuation and continuation of your will, but they are also many more things beyond that. They are declarations, they are juristic acts, and some of them are contracts, and some of them are offers of contract. So we make sure that we sign and seal every single one of them. So, and here it says the unnecessary addition of a seal does not change the essential character of the instrument, right? Okay, subsection 40, attestation. The English statute of frauds requires the attestation of wills by 3 or 4 credible witnesses. Now, anybody who's done their doc set would recognize that fact because we make sure that we do all of the documents by 4 credible witnesses. Why do you think I did that? It's for this reason, okay? So that they're properly attested, right? So this is the reason why we do that, by witness quorum of 4 people. Because this is the actual attestation at the bottom of all the vocational science freedom status documents. So I'll read that in a minute, but first I'll read this. Okay, so the English statute of frauds requires the attestation of wills by 3 or 4 credible witnesses. By subscribing the same in the presence of the testator, a similar provision is incorporated into the statutes of all the states, right? So if you don't have your will signed by people, it's not going to be valid by any of the states anyway. So know that. All right. Varying, however, as to the number of witnesses required and as to the further requirement that the witnesses shall subscribe, quote, in the presence of each other, close quote. Wills devising real estate are required to be attested by 2 or more, or at least 2 witnesses in Alabama and all the rest of these states. And in Louisiana, the forms of the civil law, Roman civil law, because Louisiana is a Napoleonic law state, are followed to some extent, and 3 resident or 5 non-resident witnesses are required for non-competitive or open testaments, while a mystic, secret or closed testament must be delivered to a notary public in a sealed envelope. And I made a point here to put in the definition of a counterdeed. I talk about this all the time, but I don't always tell the totality of the definition. So this is the definition of counterdeed. This is out of Black's Law 9th. You're not going to find this definition in Bouvier's, by the way. Counterdeed, a secret deed executed either before a notary or under a private seal that voids, invalidates, or alters a public deed. So when you come along and you've created a public deed, something you've done, you have a public deed done. Then you go wandering in front of a notary and they put their notary seal on it. What did they just do? They counterdeeded your deed done. Okay? And that then ends up with this secret part, even though here they're also technically talking about a secret testamentary will that you put into an envelope that you don't want anybody to see at all. like any part of, and then you're sealing it for a later purpose, and that it's witnessed by these five 5 non-resident witnesses. That's what this is technically talking about. But because of the fact that it brought up while a mystic secret or closed testament, I thought it would be important to just show everybody here what a counter deed is. And that it's a secret deed executed before a notary or under private seal that voids, invalidates, or alters a public deed. Now, this is something that Tammy taught me. He's like, you never want to go before a notary to do anything, because they're counter deeding everything that you're doing, because they are priests of El. They're priests talking to the dead, because a notary is an ecclesiastical position, and they're talking to the dead thing. And that's why they always, by all the state statutes and the notary books, they always require you to what? Produce a valid ID, produce the validity of the dead thing, right? Because every state ID is always going to be in all cap letters, right? Well, they're saying here, produce the dead thing, which is, of course, your estate. But the point is that that's what the notary requires to then counter deed your deed done, which is, okay, so this is why, again, up here, why we have the witness quorum, and we don't do anything by notary. There's only one document by suggestion from a friend of mine, but I made a very, very clear point in the place where the notary jurat is that this notary jurat does not alter any aspect or move this document into any other jurisdiction, and is only for the validation of identity, and meaning also in the present, meaning of the man, I said. So there's only one place that does that, and the only document that is done is the Declaration of Nationality, because the individual who was speaking to me said that if you do not have a notary sign a willful removal 14th Amendment citizen, meaning your expatriation doc, basically. So he said that there was some place in USC that said that a notary had to have signed a document regarding an expatriation. I figured, okay, fine. That seems logical, because if the infant wants to leave daddy state, well, then, okay, probably they're going to demand that a notary be there, right? Well, okay. So I said, fine, I'll just do it on just that document. But again, it's clearly stated on the Declaration of Nationality that the only reason that the notary is being used is for identification purposes and not to alter anything with the jurisdiction of the document itself. So now I will read the attestation that we have at the end of the Vocational Science Freedom Status Docs. Okay, so we, living souls manifest, now bear witness with our own eyes and attest through our own hands, in the presence of each other, the perfect free will writing of declarant and the execution of this declaration by declarant. And the word declaration might be changed depending on, obviously, what it is. If it's not declaration, then this word would be altered. By declarant. We, the undersigned people of our respective states, having personal knowledge of declarant's identity, knowing that declarant has come to of full age, that declarant is one of the people of wherever they're from, finding said declarant to be living, and being familiar with declarant, are hereby witness to the execution of this declaration. Witnesses hereby verify, acknowledge, attest, which is the attestation, validate, and certify the free will, free act, and deed, authenticity of the signatures herein, and the identities of the people so signed, and that declarant executed the same in the capacity stated herein, for the purposes herein contained, and do hereby covenant and agree under the pains and penalties of perjury, under the laws of the United States of America, which means without the United States, by the way, and under the common law, that this declaration is of declarant's own free will, free act, and deed, and a lawful juristic act, and hereby assure all who these presents may reach, which is kind of the old way of making sure of a presentment, right? To say it that way specifically. You'll also see this in land patents too, to say that, to assure all who these presents may reach, that this declaration is executed without concealment, vexation, or intent to defraud the above stated estate or trusts. It is therefore hereby resolved that we, the undersigned people of our respective states, being personally familiar with declarant, do hereby ordain and establish this matter as truth and law, signed and sealed this such and such day of whatever year, by the sovereign authority of declarant and the undersigned witnesses below. So everybody signing is a sovereign. Okay? And we're declaring it, ordaining it, and establishing it to be truth and law. You can do that, obviously, because you can ordain whatever you wish to. Was the Constitution the same way? Yes. Just read the preamble. We, the people, do what? Hear, ordain, and establish, right? So you can do that anytime you want, as long as you're operating in your sovereign capacity. So that's how we take care of it in the VSOF status docs as far as the final part of each document at the end where the attestation happens. Okay. Section. Okay. Here. All right. So I read Louisiana, did counterdeed. All right. Next one. With the exceptions of Arkansas and New York, those statutes are held not to require attestation by signing in the presence of the testator. And of Pennsylvania, where it is held that the witness are not required to subscribe their names at all, and with the exception of holographic wills authorized in some of the states without attestation. The attestation witnesses are required to subscribe the will in the presence of the testator. Now, what's a holographic will? That just means one that's basically spoken. So basically a spoken will. Okay. And so now I'll skip down to the next highlight. It is required by statute in some states that the subscription of the attesting witnesses, like that of the testator, be at the end of the instrument. Where such is the law, the will becomes void if the testator, after proper signature and attestation, adds a disposing clause, which is again signed by him, but not attested. So it's important that that's it. So once the attestation happens, that's the end of the document, right? That's where it quits. But by the Wills Act and under American statutes generally, it is required that the testator shall sign or acknowledge his signature in the presence of the attesting witnesses, which is why you just all do it together, right? And skip down to the next section, which I think might be a little ways down here. Okay, subsection 41, competency of attesting witnesses. The statutes mostly require the witnesses to be credible or competent, by which is meant that they must be competent persons to testify in a court of justice, not being disqualified by mental imbecility, interest, crime, or marital relation. So this is the reason why I wrote the attestation, or what I just read, the way that I wrote it, because I wanted to make sure that, hey, everybody that's signing this thing has come of full age. We're all competent here, right? So there's nothing that you can possibly say later that would say, well, this is an invalid document because how do we know that these people were credible, and how do we know that they were not to be disqualified by any sort of mental incapacity? Well, it's written right there. Okay. So, all right, now we're going to skip down to chapter 6. So this is quite a few pages down. So we're going to go all the way down to page 268, down to chapter 6, revocation of wills. Subsection 48, revocation by canceling, obliterating, burning, etc. The power to revoke a will is self-evidently coextensive with the power to make one. So if you can make one, you can destroy one. And that means that you can destroy any other, any other unlawful administration that might be happening to your state, right? So just those two things go hand in hand. Just know that. It follows from the ambulatory quality of the instrument that the latter will supplants a former one, precisely to the extent to which the latter is inconsistent with the former. It is always the last will and testament which is valid, right? So if all of our estates are being probated and all this administration is happening and there's never been a valid will ever, okay, the first time that you put one down, that is the valid will. That's the first time that it hits the record, which is why we do everything the way we do as a continuation of your will. But to continue, but revocation may be effected by other means if the testator does not wish a mere alteration or change in the shape of his testamentary disposition, but an entire revocation, leaving it to the law to regulate the descent of his property. In such case, the revocation is accomplished by the cancellation or destruction of the will without more, meaning all he's got to do is rip it up. Revocation also follows by operation of law from any subsequent act of the testator inconsistent with the device or bequest, or from changes in the family relations of the testator arising after the execution of the will, unless by some act of the testator or provision in the original will, the presumption of law is rebutted. Hence, the subject of revocation of wills, whether by act of the testator himself or by operation of law, is the occasion of many statutory enactments and legal rules, and occupies much space in the books treating of wills. So from that standpoint, basically what are they saying is that they're just saying, okay, if you want to get rid of it, the revocation by operation of law is just you destroy it, right? And that the act of the testator is arising after the execution of the will that by operation of law, meaning that, okay, I destroyed it or I created a new one. And every single time that you create a new will, guess what? The old one is gone. So if they've been probating your will under administration and you come along and you create a new will and say, nope, this is now the current will of everything that's supposed to happen with this estate. What happens to everything that they had set up before regarding administration? It goes bye-bye. Okay, that's the point. All right, now I'm going to skip to section 50. That's page 275. Like I said, we're going to be skipping around here a bit because there's a lot of stuff in this treatise that I just don't need to cover. Okay, subsection 50. Revocation by subsequent will. It is usual to the insert in wills, sometimes or even where the testator has made no prior will, a clause revoking all former wills. But whether there is an express revocation or not, it is obvious that a will executed under the formalities prescribed by statute to authorize a valid disposition of the property which it devises or bequeaths must operate to revoke and annul all previous inconsistent testamentary dispositions. That's the fucking point. To operate to revoke and annul all previous inconsistent with what? Your will. Testamentary dispositions. That means give me my shit back. Black robe priest of El, right? That's what that means. Okay. So skipping down, 51. Effective subsequent upon prior wills. A will or codicil containing a revocatory clause sufficiently attested, together with new testamentary dispositions, revokes the prior will, whether its own dispositions are valid or not. If not sufficiently attested as a revoking will, but valid as to some or all of its testamentary dispositions, it revokes all former dispositions pro tanto. But if its revocatory clause be valid and all other dispositions invalid, its effect will be to render the testator intestate, meaning you don't have a will now, as if he had made no will at all. Okay, so to break this down as to what they're doing in the court system, you go in there and you say something about, I don't want that. I don't want that to happen. No, right? And any of these negative things, right? So you're saying, no, I don't want that. But then you're not ever saying what you do want them to do. You just put yourself back into a position of being intestate again. And surprise, surprise, that makes perfect sense. Because if you don't ever come forward in the court and say, this is my will, Your Honor, I'm the sole lawful executor and heir, and I demand immediate livery and a full accounting of the entire gross estate, named or known as, John Henry Doe, whatever your full name is on the birth certificate. Well, you could continue that. You could continue it all kinds of ways, but I won't digress into the other things you could say. But that's basically tantamount to all it would need to be stated. To say what you want to be done. But if you just constantly say, no, I don't want that, I don't want that, no. Okay, that's what it says here. But if the revocatory clause be valid, all of the dispositions invalid, its effect would be to render the testator intestate, as if he had made no will at all. This is why I get on people about, you can't prove a negative. You should always state things in the positive as to what you want to be done, what you are, right? Instead of trying to say what you're not, right? I see all these people writing documents say, I'm not a 14th Amendment citizen. And then they don't say anything else. Okay. You can't prove a negative. So what are you? And then, unfortunately, most people that I've seen, the things that they write, they'll say, I'm an American state national. Well, there is no such thing. It doesn't exist in the United States Code. So anybody that's using that term is incorrect. You can say American citizen, that's fine. That's something that's stated in the Expatriation Act. You can say one of the people of the several states of the Union, which is a fairly long-winded sentence, but at least that is correct. But the people out there, they're saying, I'm a state national, or I'm an American state national, or I'm even an American national. All of that is nonsense. None of it exists in law. And if you're not going to use a term that exists in law, then you'd better define it. And if you don't define it within the document, you have just absolutely and unequivocally proven that you are incompetent. Okay? And that's the last thing that you want to have happen, is that the court deems you incompetent, because then they'll take back control over of every single aspect of your estate, and they will be happy to throw you in a loony bin for a while, which I've known several people that's happened to. They tried to do it with me, but fortunately, I got out of there fast enough, meaning somebody bailed me out, right? They had intention to send me there too, because I had completely taken back over the court, and even the judge was trying to run out the door until I said, objection, sit down. But back then, I didn't know how to finish it. Now I do. And by finishing it, I mean stating what I just stated. You state what you want to be done regarding the estate, okay? All right. Okay, so that's all I have for tonight. I'm going to end it here. Is there anything anybody would like to comment on or question, or was there anything? It doesn't look like there was too much chat going on. But if anybody wants to ask a question or unmute, feel free to do so now, and we can talk. Okay. Doesn't seem like anybody has anything to add or subtract. So with that, I'd like to thank everyone for coming. And this has been the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And if you found this class to be informative, please like and subscribe to the Vocational Science Freedom on whatever platform you may be listening to this on. And I will see you guys next time for the Vocational Science Freedom Wednesday night open roundtable. And until then, enjoy the rest of your weekend. And as always, stay safe and stay sovereign.